So we talked in last week about how it works when this ownership is split into legal and beneficial rights, and that's because the trustee has legal ownership and the law recognises them as the owner, but equity gives the beneficiaries the right to compel the trustee to use that legal ownership for the beneficiary's benefit. And the subject guide goes through basically what this means and what specific rights a beneficiary can enforce against a trustee. So the fact that they have a right to information, they have a right to be kept informed, and the trustees, have a duty to produce trust accounts. So they have to account for how they've spent the money and where the money's gone and where the money's come from. And that's so that everything is clear to the beneficiaries, and the beneficiaries have the information that they need to make sure the trustees are doing their job. I think that's all fairly straightforward. Obviously, you need to do the reading around that, but I want to touch on the Saunders and Vautier rights. So ultimately, if you have a fixed trust, and let's say there's only one beneficiary, that equitable interest that they have to compel the legal owner to act in their best interests goes all the way to saying to the legal owner, I want you to transfer this right, this ownership of this house, this money, these shares in a company to me. And if there's one sole beneficiary and there's no other objections, so obviously they can't be a minor, they have to be of age, there might be something else. So perhaps maybe they're disabled, or there's something in the trust that prevents them from doing that. So maybe maybe the person who set up the trust, they set up, so let's say it's a father who set up the trust for his son. Normally the son just would have inherited money when the father died, but the father thought, my son's not very responsible with money, and so put clauses into the trust to prevent the trustees giving the money over to him. But normally, actually, the beneficiaries have a right to, under Saunders and Vautier, which was the first case where a beneficiary did that, to say, I want the rights transferred to me. That's in my best interests. Where this gets more complicated is where there's more than one beneficiary. Now, it might be that they're still fixed beneficiaries. So let's say our father leaves it to his son and to his daughter. He creates a trust. They both get 50-50. But let's say the daughter decides that she doesn't want the trustees, maybe she doesn't trust the trustees, or maybe she wants to liquidate. Let's say the father leaves a farm on trust, and the daughter decides that she doesn't like the way the trustees are running the farm. She thinks she wants half of the value of the farm, and she wants to run it herself. Now, if it's something like a bank account where the money can be split in half, the trustees probably can't say no. There's no good reason why she can't have her half of the money and leave the trust. But if it is something like a farm, remember that the trustees have a duty to both beneficiaries, so both the son and the daughter. And if they sign over half of the daughter's rights, sometimes that's going to devalue what the son still has. So with a farm, yes, the value of the farm might be the rental income or the livestock that's grazing on it, or the amount of corn that it's producing, but also the resale value, so how much the farm can be sold for. And somebody is likely, so let's say the farm is worth 10 million shillings, that's quite a cheap farm. If it got sold all as one, the daughter would have a right to 5 million shillings and the son would have a right to 5 million shillings. But if the trustees have to transfer half of it to the daughter, so then the farm has two sets of owners. It has the daughter on the one side and the trustees on the other side holding it on trust for the son. The value of the farm is essentially lessened, or the value of each half of the farm is lessened. Because if you think about it, a buyer doesn't want to buy half of a farm. They want the whole farm. And so the trustees have to either get the daughter's agreement to sell, and then, there might be some friction there. Maybe she doesn't want to sell, maybe she doesn't agree with the purchase price, or the trustees can try and sell. Maybe they need to liquidate it because the son needs the money, but half of a farm is worth less than half of the purchase price of a whole farm, because if you're purchasing a farm, you don't want to buy it with someone else also having the rights. If you think about a house, for example, somebody wants to buy a whole house. If you're buying half of the right of a house, then that's going to be worth an awful lot less, because you might not be able to live in that house if the other owner doesn't let you. So yes, the farm, let's say it has a farmhouse where somebody lives in, yes, it might be worth 10 million if it was sold as a whole, but if you just sell the rights to half of that farm, maybe it would only sell for 2 million, because it's going to be a lot less attractive to a buyer, because someone else has a right to stop you using that farm as you would want. And similarly with shares, so think about shares, and shares is the example that they give in the subject guide. We talked about stocks and shares for a public company, and I think you have done company law, so you know the difference between a public and a private company. The stock exchanges is public companies, so where anybody can buy or sell shares. But a lot of trusts might be trusts of, let's say, the shares in a family company. And so the value of a family company is, one, how much money it makes for each of its shareholders every year, but also how much money it could make if it was sold on. So let's say a family build up this company and then they sell it on to someone else. Now, if, let's say, our sister and our brother have an interest in half of the trust each, so the trustees hold the company on trust for them, and each one of them is interested in 50%. If you think about the way that a private company works, 50% of a company is normally worth a lot less than 51% of a company, a lot less. And that's because of the voting rights. So a trustee, if they give the sister half of the company that she's asked for, they might not be able to sell on the son's half for anywhere near as much money, because there's no longer a controlling interest in the company. So a buyers probably want to buy 100%, but they may agree to buy 60% so that they're able to get every resolution that they want passed. If they can't get 50% or 51% of the voting rights in a company, then a minority shareholding is worth a lot less, because you don't have control over that company. And so that's the issue with shares, is that 50% of the value of a company is a lot less money than 51%. If you get 51% of the shares, you're probably going to pay more money, a lot more money, than if you just get 50%. Because 51% gives you a controlling share, so you can push through resolutions and you can control what the company does and agrees to. Obviously, this does depend on the company's article, but that's normally how companies are set up. Then 50% or 49%. And so when the sister goes to the trustees and says, I want you to transfer half of the shares to me, they have to bear in mind that they have a duty to the brother as well to maintain the value of what they hold on trust for him. And that's why it's more difficult.